So we have a young lady who wants $500 for a car she didn't fix, and we have a father and a son who want to say, my son would never hit somebody who is passing in front of him. And we need to decide which one of these stories shall prevail. And I don't have any other questions, and I'm the last person. So I think we're going to excuse you all while we deliberate this matter. Thank you.
This courtroom is now in recess.
Well, it's some interesting twists and turns as the case progressed. As far as the contributory negligence issue is concerned, if anything, she was slowing down, not speeding up, so that didn't fly. But the troubling question to me is that she's not out of pocket.
We didn't ask an important question, which is that, is she leasing this car or did she buy it? Because if she's leasing it, then all she has to do is take the car to the dealer. They will charge her for damage to the car.
She said they totaled it.
Yeah, they totaled it.
So, was the valuation by the insurance company reduced in any way by a deductible? But who determines in a lease arrangement
the value of the car?
The value of the car is? And you have insurance on that leased car in your name, and there's a $500 deductible. Let's assume these other subsequent accidents didn't happen. She would have been out the $500. Am I correct?
Well,
correct.
Yes, or she could have.
So does it really matter? Does it really matter that it was a lease?
No.
Well, if it doesn't matter, then she's not out of pocket anything.
No, but she will be out of pocket.
No.
She will be out of pocket to get, okay, here are the facts as I understand them. The car has been damaged, the car's not been repaired. She has testified that she wants to get the car repaired. She's provided 3 estimates as to what it would cost to get the car repaired. Then the car is totaled.
Now, unfortunately, she did not reveal to us. It was only through our questioning that we determined that she didn't have the car anymore.
Correct.
I think she'd have to prove that the money that she got for the car, because it was totaled on her insurance policy, was devalued by $500.
Let me put something else.
And I didn't see that. I didn't see that.
In fact, we were under the impression that she still had the car.
That's correct,
and was going to get it.
Let me put something else out there. She has the car. It's damaged. She's going to get it fixed tomorrow. They steal the car. She has no car. They cover. She's not out of pocket anything. So I don't think I can give her any money.
I'm afraid that that's the way I come out on this.
If that's it, if that car were gone completely, if somebody stole it,
yes,
she would have nothing, and we couldn't say, well, you were going to get it fixed tomorrow. Here's your $500.
And then the only remaining part of the claim is the pain and suffering, which is really just a claim that she wants to make.
I know.
Because she's annoyed.
Because they didn't like her 3 estimates.
They didn't like her 3 estimates.
She's a nice person, but she's unfortunately out in this case. Dismissal of the complaint.
Yeah.
Indeed.
All right, we have one very important question we need to ask in order to be clear with respect to our verdict in this case. Ms. Pride, was your car a leased car?
No, it was owned.
Oh, it was completely owned by you?
Yes, by me.
And did you get money from the insurance company for the
As
total?
the final, yes, the write-off.
How much did they give you?
$69.
$6,900 for your car? How much did you pay for it?
$27.
So you paid $27,000 and you got $6,000 in change.
Yes.
All right, I think that revises our
yes.
initial assumptions.
It does for me, yes.
I'm looking at...
I know you're looking at me. Sure, I'm fine with going along with the 500.
All right, so this is the way we've analyzed this, all right? I think it was a plausible assumption on your part that you could argue in this case that there was some contributory negligence by the plaintiff, but the objective evidence leads us to conclude, the objective evidence being the fact that there was a speed bump, that it would have been more probable that the plaintiff was slowing down as she passed by. She wasn't speeding up, as you might have imagined. And therefore, we found there was no contributory negligence. With respect to pain and suffering, that is compensable, which the courts can pay a victim of an accident for, has to be a pain that is somehow caused by and related to the accident itself immediately, in the sense of the impact of the accident. Pain and suffering would come if you had to go for therapy afterwards. You wanted pain and suffering because of the frustration that you were facing, essentially, because you weren't able to get the insurance company to pay what you want. And that isn't what we mean by pain and suffering. All right, so our verdict is in your favor, but it is for $500, the deductible that you were requesting.